Hello, consider a prenuptial agreement if you have at least one of the following situations. Number one, you are the person who will bring a lot of assets to the partnership, including a retirement account. You have children from a prior marriage. Number three, you own your own business or are a partner in a company. Number four, you are on a fast career track and are likely to earn a hefty salary in the future. Number five, you are an Indonesian planning to marry to a foreigner. Number six, anyone who is paying for his or her spouse to get an advanced degree which is likely to result in a significant future earnings. Number seven, you plan to purchase land or a home in Indonesia during the course of your marriage. The prenuptial agreement in Indonesia is honored and can be upheld in court. The laws governing prenuptial agreements stipulate that the agreement should be made prior to a marriage. The legal grounds for the prenuptial agreement come from several applicable Indonesian laws, which is including Civil Code, 1974 marriage law, and the compilation of Islamic law. You see, Indonesian law does not provide a ready-made framework for a prenuptial agreement. You and your fiancé have leeway to define your future legal relationship, although you are bound by law, religion, morals, and public order consideration in drafting the agreement. An Indonesian prenuptial agreement must be tailored to the particular needs of the husband and wife and be sufficiently flexible to take into account changes. At Wijaya & Co., we provide clients with a prenuptial agreement questionnaire. The main purpose of this questionnaire is to gather facts and obtain clients' input on issues that should be incorporated into a prenuptial agreement. The questionnaire consists of issues that should be considered when you enter into a prenuptial agreement. It can be difficult to discuss every issue that listed on the questionnaire. When you are ready with the answers, the couple may sit down together to discuss every one of the questions, even if they are difficult to be resolved. Legal constraint for a mixed marriage. If you are a foreigner and plan to marry an Indonesian, you need to get a prenuptial agreement, considering that foreigners are not allowed to legally own property in Indonesia, and if you wish to take the quite sensible precaution, a prenuptial agreement for the purpose of protecting yourself and your properties in Indonesia are recommended. A prenuptial agreement is a must-have choice. The Indonesian government can, by law, take virtually every purchased property away from the grieving party if they did not create such a protective documents prior to their marriage. The prenup creates a legal framework for a property separation in your marriage and therefore preserves the right of the Indonesian spouse to own property in Indonesia. The property ownership must be under the Indonesian spouse's name as the title holder. In the event the foreign spouse passes away, the Indonesian spouse may keep the property for good, forever. The marriage law in Indonesia is applicable to all Indonesians and to all marriages registered in Indonesia. Furthermore, the basic property law, which is enacted in 1960, in Indonesia does not allow foreigner the right to own property in Indonesia. Therefore, when an Indonesian is married to a foreigner, she or he will be precluded to legally own the property. Furthermore, the Indonesian marriage law assuming joint property ownership for every marriage without a prenuptial agreement. So, a joint property ownership requires consent from your spouse. So, how could a consent can be retrieved when your spouse is not in the legal position to hold it in the first place? Therefore, in order to avoid this kind of trouble, it would be prudent to draft a prenuptial agreement complying with Indonesian law to ensure that your financial interests will be upheld by the Indonesian court. I'm Asep Wijaya. Thank you for watching.